Hello, and thank you very much for the opportunity to give a little bit of insight into the development of commercial litigation funding and also then the role of regulatory bodies in different jurisdictions around the world. You'll have heard something already about litigation funding, and I think it's just important to remind ourselves that it came from a place of need for access to justice for those who had no funding at all in order to be able to bring their claims. And what we've seen is now all types of claimants are using funding for all types of cases. So where it started with those with no money, it's now used by everybody through to large corporates who typically finance all aspects of their businesses and now do so for funding as well, because they like having alongside them a funder who has experience of litigation when often they do not. And it's also used for a huge range of cases. And I think it's important to be reminded about that too. Everything from big contractual disputes, arbitrations, and then things like equal pay claims. In fact, Harbour was involved in funding a case which had a Supreme Court decision here on very recently in relation to Uber drivers and ensuring that they are paid national minimum wage. So that's just an indication of individuals or claimants who cannot afford to bring claims on their own, being able to do so with the benefit of litigation funding. I think it's also important to remember that this is about a levelling of the playing field. You will all know from your view about the costs involved in cases just how expensive running a big piece of commercial litigation can be. And you've got not just the own side cost, but you've got adverse costs to pay for. So it's a very significant sums that parties need to have access to if they're to be properly represented. And in fact, if anything, that puts defendants in a better position to know that they will have their costs covered in the event that the claim against them is not successful. I'd like to just address one other thing before I just talk about the regulatory bodies, and that's about the concern that litigation funders are creating more claims. In my experience, actually, it's the opposite. We at Harbour, we're the largest private funder in the world, receive about 40 new inquiries for funding each month. Of those, we fund less than 5% of those cases. And I think sometimes with the gentle questioning that comes from how we review a case about its ability to be enforced, the value of the case, the amount of funding required, and then the legal merits, we often make people just question the viability of their claim, and if anything, probably cause some to go away and realise that their claim doesn't have perhaps the merit that they had. And also just a sense of scale. There can be a view that some believe that litigation funders are funding all litigation and arbitration around the world. Well, again, as I said, we are the largest funder in the world, private funder in the world, and nonetheless, we fund no more than about 40 cases in the world per year. So it's a tiny drop in the ocean, and I want to just give that sense of perspective. So if you look at then what has been done on the regulatory piece of funding around the world, well, when Lord Justice Jackson in England and Wales produced his report in 2011, one of the things he suggested when he endorsed funding was that there should be a self-regulatory body formed. So we formed the Association of Litigation Funders in November 2011, and I now chair that organisation. And that was there to have a code of conduct for all members and to deal with any complaints about members from parties that had been funded. Since 2011, I think we have received no more than 6 complaints about concerns about funder members. Of those, none have been upheld. They're dealt with by an external third-party law firm, and typically it's been found that the complaints have been levelled by people who were not being funded and therefore didn't have the locus to bring the claim. If we look to jurisdictions like Singapore and Hong Kong, they have introduced legislation about how litigation funding should be administered. But as far as I'm aware, still no association has been formed in those jurisdictions. And it perhaps leaves a little bit of a gap for those who want to seek some kind of redress about misapplication of that legislation by a funded party, to do so as where they go to bring their complaints. But we are seeing, nonetheless, a continued development and formalisation of litigation funding. Cayman, in fact, has just enacted legislation to permit both and endorse litigation funding, as well as introducing contingency fees in its jurisdiction. And we only continue to see the case law developing favourably to remove any doubts about whether litigation funding is permitted in a wide range of jurisdictions. So I think the important thing to be aware is that it is now a very regular part of the legal landscape, but not in the thousands of cases, in the dozens of cases is where I think you should expect to see it. And I think that the continued development of bodies in countries to deal with matters arising in relation to funders is a continued good positive step, and replicating the models set up in England and Wales is one which people often come to us to do, and that's something that we would certainly encourage. I think my only caveat is how one deals with those funders who choose not to be members of those associations, and how one regulates their activities, and that's a matter for jurisdictions to consider on their own merits about how they think best to deal with it. But I think it's important to keep it in context about the extent of what is going on here. It is still a very small part of the costs part of the litigation landscape. I hope that was helpful, and I look forward to hearing more about the debate on this subject.